Most people think domestic violence charges only happen when someone is physically injured. A black eye, broken bone, visible injuries, something obvious. But that's not how Florida law works. In fact, some people are shocked to find themselves facing domestic violence allegations, even though nobody was injured. No ambulance was called, no hospital visit, sometimes no physical contact at all. An argument gets heated, someone says they felt threatened, a doorway gets blocked during an argument, a series of texts gets interpreted differently than intended, and suddenly police are involved. The scary part, many people don't realize they may have crossed a legal line until after they're arrested. So in this video, I'm going to explain what actually qualifies as domestic violence in Florida, why these cases are treated so seriously, and the situations that catch people completely off guard. Because what most people think domestic violence means and what Florida law says it means are often two very different things. I'm Danny Izquierdo, a Florida criminal defense attorney, and one of the biggest misconceptions I encounter is people assuming they already know what domestic violence means under Florida law. Usually because they're thinking about the worst case scenarios they've seen on television or in the news. But the legal definition is often much broader than people expect. And once you understand that definition, you'll understand why domestic violence allegations can create serious consequences almost immediately. Before we talk about what qualifies as domestic violence, let's talk about why so many people get blindsided by these allegations in the first place. Because most people aren't worried about committing domestic violence. They're worried about getting into an argument, having a disagreement, saying something they regret, going through a difficult breakup. The problem is that people don't realize certain situations can be viewed very differently once law enforcement becomes involved. What feels like a heated argument to one person may feel threatening to another. What feels like frustration to one person may be interpreted as intimidation by someone else. And that difference in perception can completely change the situation, which brings us to the question that matters most. What actually counts as domestic violence under Florida law? Here's the thing most people get wrong. Domestic violence is not a single criminal charge. It's a category. Think of it like a label that gets attached to certain offenses when they involve specific relationships. The underlying offense might be assault, battery, aggravated assault, aggravated battery, stalking, aggravated stalking, false imprisonment, kidnapping, sexual battery, or other criminal acts involving physical injury. What transforms those offenses into domestic violence is the relationship between the people involved. In other words, prosecutors don't necessarily need a charge called domestic violence. Instead, they take an existing offense and apply the domestic violence designation or label because of the relationship between the parties. And that designation can trigger consequences that make the case significantly more serious, which is why the next question becomes so important. Why does that label matter so much? Because once that domestic violence designation enters the picture, life can change very quickly, even before you've had the opportunity to defend yourself. Many people assume the real consequences happen after the conviction, but often the disruption starts immediately. You may face no contact orders, stay away orders, restrictions on returning home, firearm restrictions, mandatory court appearances, and other court imposed conditions. Think of it like flipping a switch. One moment you're dealing with a relationship conflict. The next moment you're dealing with court orders that affect where you live, who you can talk to, and what you can do. Your housing situation can change. Your relationship with your children can be affected. Your employment can be impacted. And your reputation may suffer long before your case is even resolved. That's why domestic violence allegations should never be viewed as just a misunderstanding. But here's where things get even more surprising. Many domestic violence cases don't involve the situations people typically imagine. This is where a lot of misunderstandings happen because people tend to focus exclusively on physical injuries, but that's not always what these cases are about. For example, an argument where nobody is touched could still result in an assault allegation if someone claims they feared immediate harm. Repeated calls or messages during a dispute could potentially lead to allegations involving stalking behavior. A confrontation where both people are yelling may still result in one person being arrested. And actions that seem insignificant in that moment can look very different once police arrive and begin asking questions. The important thing to understand is that many domestic violence allegations are not based solely on what happened. They're based on what someone claims they experienced, what they believed, what they feared, or how they interpreted the situation. That's one reason these cases can become extremely complicated, because once you move beyond obvious physical evidence, you're often dealing with something much more difficult: conflicting stories. Many domestic violence cases ultimately come down to two very different versions of the same event. One person says the argument became threatening. The other says it never crossed that line. One person describes intimidation. The other is describing a verbal disagreement. One person says they were prevented from leaving. The other says they were simply standing in a doorway. Relationships are complicated. Emotions run high. People remember events differently, and allegations sometimes arise during breakups, divorces, custody disputes, and other stressful life events. That's one reason these cases can be difficult for everyone involved: prosecutors, defense attorneys, judges, jurors. The facts aren't always as clear-cut as people expect, which is exactly why the decisions you make after an allegation becomes public are so important. Once people are accused of domestic violence, they often panic, and panic leads to mistakes. One of the biggest is violating a no contact order. It doesn't matter who initiated the contact. If a court order says no contact, you need to follow it. Another common mistake is assuming everything will calm down and go away on its own. Many people believe the situation will just resolve itself once the emotions cool off. Unfortunately, that's not how these cases usually work. And another mistake is trying to explain your side of the story to everyone except an attorney, friends, family, social media. Even statements made with good intentions can sometimes create problems later. The reality is that the choices made immediately after an arrest or allegation often have a major impact on how the case unfolds. If you've been accused of domestic violence in Florida, remember this: domestic violence is much broader than people realize. You do not need serious injuries for allegations to arise, and in some situations, physical contact may not even be the central issue. That doesn't mean an accusation automatically leads to a conviction, and it doesn't mean the allegations can't be challenged, but it does mean you should take the situation seriously from the very beginning. The sooner you understand the allegations, the evidence, and your legal options, the better positioned you'll be to protect yourself moving forward. If you'd like to learn more, download our free report, He Said, She Said: 3 mistakes that can destroy your domestic violence case in Florida. And if you're dealing with a domestic violence allegation that's disrupting your life, be sure to contact us, schedule a free 4-point case evaluation and defense strategy session. But before you go, there's another misunderstanding that gets people into trouble all the time. Many people assume that if the alleged victim later says they don't want to press charges, the case automatically disappears. But that's not how Florida's criminal justice system works. In fact, domestic violence cases continue moving forward even when the alleged victim wants them dismissed. So if you're wondering whether your case will be dropped because the victim doesn't want to prosecute, watch the next video. Will my domestic violence case be dropped if the victim doesn't want to press charges? Because the answer surprises a lot of people. I'll see you over there.